All right, welcome back, everybody. Thank you for joining us. I'm Ted Daniel, and with me is Peter Tragos. He's an attorney based in Florida. He goes by Lawyer You Know. He follows a number of trials, and he's been all over this one. His commentary's been great, and I appreciate him coming back to talk the last week of testimony in the Karen Read trial and sort of everything that's happened so far. Peter, can you believe we're near the end here?
It's really wild. I mean, it's a second trial is usually, in my opinion, not this different to the first trial as it was here. So many differences, different angles taken, different witnesses called, different strategies by the lawyers, different prosecutor. So it's really been a wild ride through these two trials. And now to think that we're going to have a jury verdict at any time now is pretty wild.
Yeah, the packaging from both sides has been different. The defense, I think, went more on the trying to disprove an alleged collision. The prosecution was more streamlined. Lally called everyone and their brother. Brennan did not do that. In terms of effectiveness from both sides, what's your take?
I think both sides were more effective this time from a presentation standpoint. As a lawyer watching it, it was much cleaner, much smoother, much simpler. And usually you want to streamline things as a lawyer. That's part of our job. But I will say the incredible difference in how the evidence was presented, I think favors the defense because say what you want about Lally's presentation style. It's not my favorite. I understand some people thought it was boring. Some people thought it was hard to understand, but he really painted the picture of all these people would have to be wrong if this was some kind of conspiracy or cover up or fight or whatever. Because all these people were in the house. All these people saw it was snowing. All these people walked by the yard. All these people said John O'Keefe didn't come here. All these people seem to not like Karen Read. And the defense, on the other hand, was saying, well, all these people are involved in a conspiracy, a cover up, the whole town, everybody, law enforcement, judges, prosecutors, you name it, they're all involved. That was completely pushed to the side this trial. And the Commonwealth tried to prove a car accident happened. Karen Read's Lexus hit John O'Keefe. And the defense said, well, listen here. That's not what the data and the science shows. We've got doctors, medical examiners, engineers showing that's impossible. Taillight couldn't have broken like that. Arm wouldn't look like that. He wouldn't have passed away like that. It doesn't make sense. The investigation was so bad. So we don't even know if there was somebody else involved, but we know it wasn't a car accident. And frankly, it was more likely a dog bite or dog scratch. And I think that simplicity has helped the defense.
The lawyering in this case has been diabolical. I mean,
Oh, yeah.
it's on both sides. That's what happens when you get really good lawyers. And as you know, lawyers can make an argument out of pretty much anything. We got some of the final decisions by Judge Cannoni. She, as expected, said no, she's not going to approve the required finding of not guilty. It's my understanding that that's more just sort of something you do. It happens in all the cases. It rarely gets approved. Is that correct?
Yeah, it's almost you almost never win that, especially in cases like this. But it does protect the record for appeal. It protects a lot of your arguments that you may make later, and there are some that you waive if you do not make this motion. So it's basically like checking a box.
Defense says they're not going to go with a full third party culprit. So Karen Read earlier had used the word hybrid, and that's what David Yannetti discussed in court. He said, essentially, we're going to use that in conjunction with a Bowden defense. What's a Bowden defense, and what does that mean?
A Bowden defense is attacking the police investigation, everything they did, how they didn't secure the crime scene, how the evidence was found, the issues with the videos and the Sally Port and Proctor's texts, and everything involved with law enforcement, the struggles, the problems, the leaf blower, the red solo cups. All the problems with the investigation is basically couched under the Bowden defense. And when you're marrying the third party culprit with that, instead of proving Brian Higgins did this, you can say stuff like, we know Brian Higgins was at the waterfall. He looked at John kiss Karen on the head. We saw him motion over. Maybe Brian Higgins did this, but we're never going to be able to find out because the investigation was so bad. So nobody's ever going to know what happened that night. And that is because of the lack of investigation, the poor investigation, the malfeasance in the investigation, whatever words they want to use. That's how you marry the two together usually.
Okay, and the defense also surprised me. They withdrew their request for a missing witness instruction. They wanted to tell the jury that, hey, the Brennan could have called Trooper Proctor, Brian Higgins, Brian Albert, but he didn't, and so the jury should infer that there's something negative there. But they're not going to do that. What do you think about that decision?
So this is when I have to kind of qualify and couch in where we're recording this and when people might be listening, because
Right.
I haven't seen the entire charge conference yet. I will watch that. Also, a lot of people may have already seen closing arguments, which we haven't seen. So we're
Yep.
kind of doing some guesswork
Yep.
here. It's important, I think, to give that qualification, but
Yes.
I'm a little surprised because I think that's a perfect instruction for this case, dealing with Higgins, Proctor, and Albert, for them to be able to argue a negative inference. I would still absolutely expect Alan Jackson or whoever does closing to say they didn't call Michael Proctor, but here's what we know about Michael Proctor. He's definitely going to argue a negative inference. I would think if he doesn't, I'd be completely shocked. But then again, only an hour and 15 minutes for closing. Maybe he's going to
Yeah.
focus more on the science, the data, the lack of accident, the more likely nature of a dog bite and dog scratch. So it's a lot of surprising things have happened in this case with some of the strategy for the lawyers. And I'm really interested to see if we talk to any jurors afterwards. I'm really interested to see how it worked.
Yeah, so and you're right on the hour 15, the judge sort of split it. I think Jackson had won in an hour 30.
Yes.
Originally, the judge, I think, was considering an hour. And so that's what you get. I think both lawyers could probably talk for days if they were given permission to do that,
Mhm.
but thankfully that's not going to happen. On the flip side, the Commonwealth says it is withdrawing its request for a consciousness of guilt instruction. Can you explain that?
Yeah, I mean, I think you give concessions whenever you go through this process. You get a feel of what the judge is going to do. If the other side's giving some, maybe you give some. We've seen that with some of the PowerPoints and exhibits that were entered into evidence, some agreements, some not. So I just think from this point, they're still going to argue it. They're still going to argue those were confessions. They're still going to argue she knew what she did. So just because there's not a jury instruction doesn't mean none of those arguments are going to come in for the lawyer. It just means what is the judge going to instruct the jury on?
The final witness, and I think it's telling based on the fact that the defense has been so keyed in on trying to hit the point that their data shows there was no car crash. So they end with Dr. Andrew Rentschler. And one thing that I could see is there really is a difference in a paid witness and then someone who doesn't do this for a living. I mean, Rentschler earned his money. Absolutely. He pushed back on Brennan like no one else that I've seen in this trial. And Brennan went round and round trying to get him to say that, the testing that they did wasn't accurate and, that the Rescue Randy is not an official crash test dummy. But every single time he did that, Rentschler would say, well, it doesn't matter if there was no collision. How effective do you think Rentschler was by dropping that probably 20 times in front of the jury?
Incredibly effective. And I think it is important for everybody just to realize how important it is to listen. If you listen to what the person is saying to you, the questions that they're asking, you can give the appropriate answers. If you guess and you think you know where they're going and you're already answering the question or you're already giving the answer before even listening to the question, that can get you in a lot of trouble. And I think what you said about professional witnesses being so important, if you just look at the difference between Dr. Russell, trial one versus trial two,
Yeah.
almost no experience, didn't really do it at all. Trial one, thrown into it. Trial two, she was able to prepare with this defense team, considerably better trial two. And Rentschler was considerably more in depth trial two, much longer
Yeah.
witness trial two. And I agree, he was pushing back appropriately and professionally and very calm demeanor. He wasn't combative like I think Welcher felt a few times with defense counsel when he was being cross-examined. So he just did a really good job.
Yeah, I think Brennan has been successful getting under the skin of certain witnesses, but he was not able to do that with Dr. Rentschler. One of the things that Brennan brought up was Rentschler is apparently seen in the HBO Max documentary Body in the Snow in the background of the war room or where the Reed team had been during the first trial and eating a ham sandwich. And I'm wondering if the jury kind of got all that. He almost went after Rentschler's character, saying that Rentschler was laughing it up with, members of the defense about something. I think it was a question that Lally had and his response to it. I mean, is that your take on that? That he's going after his character, saying that hey, this is not a good guy or something like that?
I think he's trying to make him seem like pompous, like a jerk, like, oh, it's so funny. These lawyers are so stupid. They don't understand what I do. And he's so in bed with the defense team, hanging out with them after eating ham sandwich, shooting the crap. To me, that all depends on the jury And when you have a jury that's with you, if they were with Hank Brennan and they liked Hank Brennan and they thought he was a great job and a white knight fighting for justice, they'll probably be with him and be like, what a jerk. Why would he be in the documentary? He loves Karen Reed that much. That's so weird. They're not with you. They're probably very annoyed you're talking about a ham sandwich. They think you're mocking this witness. They think you're wasting their time. What does that have to do with whether or not a car accident? Is that all you have, Hank Brennan? So it really depends on the way the jury is starting to feel at this point. They're probably with one side or the other by this time in the trial. And that's going to probably filter the way they look at that exchange.
One of the things that Dr. Rentschler spoke about was he went over x-rays that were taken. And that's an issue because previous witnesses for the Commonwealth said there were no x-rays, but the medical examiner who performed the autopsy on O'Keefe took them. Is that, I mean, people, there are some people who are going to say that was intentional and that's hiding evidence. You think that was just a mistake that the prosecution made that maybe initially they didn't know their x-rays were there or that wasn't shared with their witnesses?
So usually I don't like to use myself as a, example of what a
Yep.
juror might be thinking, but this moment stuck out to me because when Welcher, the Commonwealth's expert, said there were no x-rays. So we don't think there were fractures. There were no reported fractures, but there could have been because there were no x-rays. And if we really wanted to rule it out, we'd have x-rays. And I thought, I watched the whole first trial. I don't remember them talking about
Nope,
x-rays.
they didn't.
Why would they not x-ray? And if they didn't x-ray, why did the Commonwealth last trial? Why did Lally just agree there were no fractures in his arm? And then my jaw dropped when we find out later there were x-rays and the defense did not cross Welcher on it. So I don't know if everybody was thinking like I was, like, well, holy crap, were there no x-rays? And they went back and looked and there were x-rays. I don't know if everybody knew and it was strategic, but how it came across to me, the testimony was close enough in time to where I remember vividly that Welcher said that. And I thought that was a good point. I was like, I can't say for certain there were no fractures then because there could be hairline fractures and then it gets blown out of the water. And at that point, I'm like, they're sick. Their ship is sunk. Like that is such a huge problem for them that they're making arguments like that. Brennan's asking questions like that. I mean, from my perspective, it was a huge deal exactly the way it came out. And I think probably part of the reason that Welcher wasn't called again on rebuttal.
Okay. All right. That actually that would make sense. And Dr. Isaac Wolf, the Miami neurosurgeon, was also asked about the fact that, he said, well, I couldn't look at that because there were no x-rays. And yeah, I'm not sure if you'd be aware of that, but is that standard operating procedure when an autopsy is done, that x-rays of the body are taken when it's something that could be a homicide case?
So I don't remember Dr. Wolf saying that. That's the problem. It really, because again, he was a little while back, but Welcher, it sticks in my mind. And frankly, Wolf is the brain guy. So he shouldn't
Yep.
have been commenting on the arm anyways, I would have said. But anyways, yes, it is, especially though, when there's that type of injury and damage done to the exterior of the arm, you definitely would x-ray that in a situation like this.
And why it's important to the defense and was hammered home in their witnesses is their argument that, hey, there was no breaks in his arm or his legs, and that was definitively seen in the x-ray photos. And that's something that you heard a lot from with Dr. Elizabeth La Posada, who is the medical examiner that the defense hired. She used to be the chief medical examiner for the state of Rhode Island, but now does consulting. So she is a paid witness. And I just want to check my notes. A couple of things that she said. One thing that's kind of stuck out for me, and I don't know how you reach this conclusion, but she's the expert. She said, okay, so John O'Keefe had this massive skull fracture, but it had a pattern to it. There was a pattern to this skull fracture that indicated he hit something like ridged or, not a smooth surface. And she was asked by the defense, well, was there anything outside 34 Fairview Road that would be consistent that could cause the injury that he had? And she said, based on pictures that she saw, no. And also that there would have been the possibility of grass in the head wound, and there was no grass in the head wound. Is that I've never heard that level of wound analysis before. Is that revelatory, or is that kind of how what MEs are able to discern?
So I also know the defense was really trying to slip in there the pictures inside the garage, and there was some concrete
Yes,
stuff in the garage, but
I want to talk
they
about that
did come
after
in
this.
and it was struck. But so here's what I'll say about that. I did not find that overly effective
Okay.
personally. And I don't know if it was because Dr. Isaac Wolf explained it, the other Emmy explained that it absolutely could happen falling on the ground like this. That's how I kind of compare experts. I think there were
Yep.
certain things that were overwhelmingly convincing from Dr. La Posada. That's not one that I really felt. I felt like when I weighed what everybody said, it could have happened on a ridge, it could have happened on flat ground. The most effective part of that to me was not that she proved it was a ridge, but that if it did hit flat ground, it would be more star shaped. I could logically understand that as far as the head injury. I personally didn't find it that effective, but it's exactly how you determine and weigh different evidence. And I found the lack of fractures in the arm or anywhere on the lower extremities to be so compelling that when there were no x rays in my mind for that couple days, I was like, maybe I'm giving that too much weight. And then we hear about the x rays and boom, the weight is given to it again. So that's kind of how I weigh expert testimony when I hear it. And that's what I thought when I heard about the head injury. Same as you, you're like, I didn't really understand how she was proving that pattern, but she did say it. I felt the same way.
Speaking of the garage, members of the Reed family told me first time several years ago that they believe John O'Keefe was attacked in the basement of 34 Fairview Road. So, what's the deal with the garage?
My only guess is that their investigator went out there to take measurements and take pictures. He was able to look in the garage. He saw a stair on the garage. They felt like, oh, maybe that'll fit our theory of creating some reasonable doubt. I don't know that it's a real theory. I don't know that they can actually prove it. I think they're just trying to give the jury other options. If you want my honest opinion, because I've heard the basement, the weight bench, the
Yeah.
dumbbells. I've heard all sorts of different theories. So I think they're just trying to throw a theory out there and try to give the jury, if they're sitting back there, a jury usually wants to know what happened. If they're going to say not guilty, then how could this have possibly happened? Maybe they'll sit back there and say, there was a stair in the garage. Could have been that. And if you give them an option of what could have happened, kind of like a third party culprit, if not her, then who? Maybe it was Higgins. Maybe it was Albert. We don't know because the investigation was so bad. Defense attorneys like to provide those options to jurors.
Robert Alessi made an argument for a mistrial that regarding the fact that Hank Brennan showed John O'Keefe's sweatshirt and there were holes in the back of it, and he asked a questions about those holes, and he asked a question about those holes, inferring that those were part of the collision. Well, it turns out those holes were made by the state police for testing. Brennan admitted he made a mistake here. On appeal, how powerful is that issue?
So, from my perspective, in conjunction with some of the statements and questions and actions of Hank Brennan throughout the trial, I think the defense is going to have a pretty strong prosecutorial misconduct argument on appeal. He continues to say things like, well, don't details matter? Or, well, that's not what you said before. Or, because Mr. Alessi told you to ask for every transcript. When he does those windups, we as lawyers know you can't. Defense lawyers sometimes do them. They'll push, they'll talk about the garage, because if a defense lawyer wins, it's over. They're not going to get an appeal. Double jeopardy. But prosecutors are usually a lot more careful, and he hasn't been. He has gone overboard doing that. So, in conjunction with things like asking questions that you either knew were false, you either knew those holes came from the criminalist, is that what they called her?
Yeah, Maureen
Or
Hartnett. Yep.
right. Or you should have known because that's your testimony, your witness, your evidence. So you either knew or should have known. You can't make those mistakes. He admitted it. Most judges would not declare a mistrial at that point, but they would have given a much stronger instruction, which Judge Canoni did not. I know they were still kind of arguing and pushing for more. So I don't know if that ended up happening, but she should have admonished Hank Brennan in front of the jury to try and take away some of that sting. And on appeal, you would have said, well, the jury knew the prosecutor was wrong and maybe had a negative view of the prosecutor. And if they still convict her, then it makes it less of an appellate issue. But that's just not how it came out with the instruction.
Yeah, I mean, the defense, there certainly seems to be, there's no love between the defense and Judge Canoni. That's clear. But, and I guess it's a fine line. I remember covering the first or the second Aaron Hernandez trial in Boston, and it was Jose Baez and his team. And Baez felt that he was getting a bad shake from the judge, and he stood up in court and said that to the judge. You are not treating us fairly. And it actually changed. The judge actually said, I'm sorry. Okay, I'm going to sort of change my demeanor with you. And it worked. I don't think that would necessarily work with Judge Canoni.
No, because Judge Canoni doesn't come across as like a jerk to me. She just kind of comes across as exacerbated and frustrated. And a lot of judges, that's kind of their personality. And the lawyer they think is maybe causing more of the problems is who that's more directed to. And they have a lot of other thoughts and things that they see in the background that I think cause them to react and to act that way that sometimes we don't always see. So
Yeah.
I don't think there was really much the defense was going to do to change that.
All right. So we are could have a verdict at any time now. Depending on when people are watching this, I guess if I was going to put a day on it, my guess would be Wednesday. What's your thought?
Honestly, if it wasn't for the last trial, I would say by the end of the day, Monday. They start talking about it Friday. They work through it Monday, and by the end of the day, Monday, they're done. We've been here for 32 days or whatever it's been. That's what I would have guessed. Based on the last trial, though, you're probably right. It's probably going to last longer than you'd expect.
Because all it takes is like a couple people on either side to be absolutely, you know, decide that
Entrenched.
they're not going to move either way.
Mhm. Yeah, that's very likely in a case like this, especially. But again, that's why I like that it doesn't feel as much of a juxtaposition between Karen Reed, somebody accused of murder, and cops, because when you do that, then you can have people really entrenched. It doesn't quite feel like that this time. This time, it seems like a simpler question before the jury. Did a collision happen? And I think it's possible all those jurors are like, I don't think it happened. So how can we convict her if they didn't prove a collision happened? They're much more likely to say that than 50 people, including cops and federal agents, are involved in a conspiracy. It's much less likely that 12 people would ever agree on that.
Yeah, and that, as we said, that's how the defense ended. That is sort of the crux of this trial of the case that they're putting forward.
Mhm.
Just so everyone knows, we are working with Peter to see the possibility of him joining us for verdict on our broadcast on TV. Obviously, we're still working that out because Peter has his own stream and he's got a huge audience, and people are going to be wanting his opinions and going through that. So if it does work, hopefully that would be great. But we'll see. We'll talk about that further. Peter, you've been amazing to give me all the time that you've given. Hopefully we can do this once more, you and I, when everything's all said and done.
Yeah, absolutely, man. Thanks for having me. It's been fun. It's been a wild ride, man. I've
Yeah,
enjoyed
it
these
has. It's been
conversations.
an absolute. It's like I don't know what I got to go back to, like go back to my real job after this, and it's like I've been so engrossed, and my life has just been for 3 years now. This has been it. This is all people want to talk about, and
Mhm.
it's gonna be a wind down, I guess.
Yeah, for
Probably
sure.
the best way to say it. All right, dude. Good to see you. Thank you so much, and appreciate your time.